Because she was charged with handing over the phone, they do have the right to review the evidence that was in the phone. But in going through these text messages, she's saying incredibly incriminating things to the other people in the chat. So really just not a good idea. Welcome back to the channel, everyone. In today's video, I'm reacting to the bizarre behavior of a licensed attorney who's now unlicensed. First, she had a relationship with a client. She gave that client a cell phone in jail. She put a hit out. That's right, a hit out for their death. I like to call this the perfect trifecta of what not to do.
Never even heard of this, let alone seen this.
We go to a hearing in Las Vegas, Nevada.
Obviously, it's got to be Las Vegas, right? Can't be any other state.
Alexis Plunkett, who also happens to be an attorney. 2 years earlier, Plunkett was visiting her client and boyfriend at the time, Andrew Arevalo, at the county jail. And that's when she broke the law by handing the phone over to Arevalo.
That's a big problem. When you go to most county jails or state prisons, there's usually a sign that says no cell phone. Obviously, you cannot give a cell phone or any electronic device over to an inmate. People don't realize that when there's an attorney in the room, they cannot listen to what's being said. They can record and they will review it. And by this attorney handing over her phone like that, that's a very big problem. I mean, she definitely knows better or should have known better.
This is a felony, and if convicted, Plunkett could be looking at a year in prison. Later, when police examined her phone, they also discovered some texts that would become the focus of a truly bizarre story. Plunkett had written to a group of attorneys that she'd placed hits on Arevalo in every Nevada prison.
Because she was charged with handing over the phone, they do have the right to review the evidence that was in the phone. That includes any of the text messages. I mean, in this situation, there were 6 other people. Look, obviously she has some issues here, some mental health issues. It's kind of sad to see an attorney do something like this, but in going through these text messages, she's saying incredibly incriminating things to the other people in the chat. So really just not a good idea.
When one of the attorneys wrote it wasn't funny,
I love how the attorney wrote it wasn't funny.
Joking.
So it's clear that he had nothing to do with it.
Plunkett's complete 180 regarding Arevalo was because, according to Plunkett, her client had physically abused her. Now, because of the cell phone charge, she appears before Judge Michael Villani, hoping to be released on bond.
So what that really means is if she's released on bond, she posts a bond through a company for her bail. For example, if her bail is set at $100,000, the judge can say you have to post a 10% bond. You post 10% of that with the bond company. They put up the rest to assure that you come back to court. If you don't come back to court, you forfeit all of that money, and now you owe that bond company the remainder of the bail amount, which would be $90,000 if it was a $100,000 bond.
When the investigating officer, who asked to remain anonymous, takes the stand, he says Plunkett claimed the texts were just a way to let off steam.
It's a weird way to let off steam.
Just explained it away as venting again. I told her I didn't quite understand how this was venting.
I don't think anyone understands how that's venting.
This is more than just venting, and asked that Plunkett remain in custody.
So what that means is she would remain in custody until the trial date or until the case proceeds. Typically, when you go to a bail hearing, your attorney would have to prove to the judge why the court shouldn't worry about the person not returning. For example, if they're a flight risk, they'll usually surrender their passport. If there's any community ties. That's why I tell my clients when we do bail hearings, I want as much support as they can get. I do tell them to have their family come, just to kind of show the judge that they have a family support system. I do voluntarily surrender the passport, although sometimes that's a condition of being released.
This is bizarre. There's nothing to say. Who in the right mind would send these texts? Like I said, I've been doing this since 1982, and I've never even heard of this, let alone seen this.
He's so taken back.
In a gang case, and we had the same text, there wouldn't be any hesitation for that person to be in custody.
And he's absolutely right. I wonder if she actually put a hit out or if it was just in the text messages.
This case is moving forward.
Trial is firm, it's going forward. If you have any motions, file them now.
What he means by motions, something called dispositive motions, meaning if you're going to file a motion to suppress certain evidence or to exclude certain testimony, you have to do that before trial, and the judge will typically set deadlines as to when those motions should be filed.
But before the case gets to trial, Plunkett is arrested again, this time for
making
threats and intimidating a witness. Plunkett allegedly called a potential witness a snitch over social media.
So here's something you don't want to do. You don't want to be released on bail where the judge kind of gives you the benefit of the doubt and then you commit another crime. Get off social media. Don't go on Facebook. Don't go on Instagram. Don't go on Twitter, TikTok, or any of those apps. Just delete it if you can, because anything you post on there could very well be used against you, and that's what happened here.
The prosecution again wants her bond denied and reminds the judge about the threatening texts.
She has said in these texts what she wanted to do. She wanted to have Mr. Aravello killed or beaten down severely.
This time, Judge Villani agrees.
She is to be held without bail pending the trial in this matter.
So it means literally what he said. She's going to be held in jail until the matter is resolved, either by plea bargaining or by trial. Those are pretty much the two ways that matters could be resolved, or if her attorney files what I talked about before, which is a dispositive motion.
Plunkett would later strike a deal with prosecutors. She pled guilty to one count of possession of a telecommunication device by a prisoner. In exchange, the criminal charge of bribing or intimidating a witness or preventing a person from testifying was dropped.
When they say a case was dropped, it means that the case was dismissed. If you're charged with, let's say, 4 crimes, the prosecutor, in his or her discretion, can dismiss 1 or 2 or 3. Typically, when an attorney advises on whether or not to take a plea, you kind of have to weigh what's less detrimental to you. In this situation here, this defendant had a law license. I'm going to assume that when they were weighing their options, they decided to take a plea that was least detrimental to her license to practice law as possible. She ultimately lost it here, but she might have not had any other choice.
Sentenced to 3 years probation. The state also recommended that Plunkett be prohibited from practicing law for 5 years and a day. But the Nevada Supreme Court went even further, and she was disbarred in the state of Nevada.
Of course she was. Typically, professionals that hold licenses, doctors, attorneys, architects, engineers, even realtors who have real estate licenses, if you're involved in any criminal proceedings, the outcome of that criminal proceeding has to be reported to the state's licensing authority. In New Jersey, it's the Office of Attorney Ethics. Also, as a general rule, attorneys should not have any relationships with their clients outside of a professional relationship. However, a relationship with a client is okay if you had a relationship with that client before the attorney-client relationship began. If you like this video, hit the like button, subscribe, and comment down below with more videos you would like to see me react to.